and he's also a nationally recognized expert on federal courts, constitutional law, national security law, and military justice. Professor Vladeck is CNN's lead Supreme Court analyst and is also the co-host of the award-winning National Security Law podcast. And I'll go ahead and plug that. If you haven't checked it out, you should. It's very entertaining. Professor Vladeck has argued numerous cases at the Supreme Court and also numerous cases at lower federal courts. Professor Vladeck earned his BA in History and Mathematics from Amherst College, and then he went on to graduate from Yale Law School in 2004. After law school, Professor clerked for Judge Berzon on the Ninth Circuit, and then also for Judge Barquette on the 11th Circuit. Also with us today is Aaron Street, who currently chairs the Supreme Court and Constitutional Law practice at Baker Botts. And there he has also argued several cases at the Supreme Court and numerous cases in lower federal courts as well. Mr. Street also serves on the board of directors and is a former president of the Federalist Society chapter in Houston. Mr. Street graduated from Hillsdale College with a BA in political science and history, and then from there went on to the University of Texas School of Law, where he graduated in 2002 with high honors. After law school, Mr. Street clerked for David Santel on the DC Circuit, and then also for Chief Justice William Rehnquist on the United States Supreme Court. This panel is going to run a bit differently than it has in years past, where this year our panelists are not only going to talk about some of the more prominent cases from the last term, but we're also going to get a good preview for what's to come in this term, which also should be very exciting. So with that, I will go ahead and pass it on to Professor Vladeck.
Great. Thanks, Pete. Thanks, everybody, for taking the time to join us. Aaron, thanks to you for taking the time from your very busy schedule. I guess, I thought a fun place to start. I mean, I do want to talk a bit about what's been in the news lately and indeed what might be in the news in the next couple of hours with this pending execution here in Texas. But I guess I actually thought it would be good to start and talk about what a difference a year makes. Right. This time last year, Justice Ginsburg was still alive. Right. She passed away September 18th. We were getting ready for what we expected to be a pretty significant term, but not quite the, I think, barn burner that it turned into. Couldn't really predict all the election stuff that was going to blow up. Couldn't really predict, at least some of the COVID stuff that was going to blow up. And so I guess I'm just curious, this is sort of a big open-ended question, but from where you're sitting, what was the biggest surprise to you about the last year at the Supreme Court?
Oh, I think it was how unusual the court's operations were. I mean, this is a court that's heard oral arguments in person for time immemorial, and for the court to go to telephone arguments was really an indication of what a severe pandemic we were under and how seriously the court was taking it. Mm-hmm. And I know you experienced that as an advocate, which I know is, not as fun as arguing in person. But other than that, I think the biggest development over the last term or two has been the emergence of what's come to be called the shadow docket, from sort of a backwater where no news was ever really made except for the occasional execution being stayed, to sort of a preview of the court's views on the merits of cases.
I think, you're preaching to the choir on that. I mean, I think there's no question that the shift in the shadow docket has been a big story. I thought it might help, Aaron, maybe I'll take a minute to just talk about what you and I mean, right, when we use that term, because I know we've got some folks who may not be quite so immersed in the concept of emergency stays and emergency writs of injunction. So the term was coined by University of Chicago law professor and former John Roberts clerk, Will Bode, in 2015. Aaron, I've always thought that Will used it basically to mean everything that isn't the merits docket, which includes a ton of anodyne stuff. It includes, applications for extensions of time. It includes, cert petitions. It includes somewhat less anodyne summary reversals. But where I feel like we've seen a huge uptick in the last couple of years is the sort of the emergency docket, the emergency slice, where, for better or for worse, and I suspect you and I might have some different thoughts about where this trend is coming from, but for better or for worse, we're seeing the Supreme Court receiving more applications for stays or to vacate stays or to grant injunctions when the lower courts haven't, all sort of at the beginning of litigation, all like pending the rest of the litigation. We're seeing the court grant more of them. And we're seeing more divisions, right, on the shadow docket. And so obviously the most prominent example of this that we just saw was the SB 8 decision last Wednesday. But really, I mean, there have been dozens of these decisions this term. And I guess I'm curious, I mean, do you have thoughts about where this trend is coming from?
Let me give a little bit of practitioner / law clerk perspective of unpacking a little bit of what you were saying about the history of the shadow docket and what we're using that term to mean. And essentially, the tradition was that there were very few emergency applications to the court. Functionally, the way it works is the application goes to a circuit justice. Each of the justices is assigned to one or two circuits throughout the country to hear emergency applications, such as motions to vacate stays and that sort of thing. And almost always, unless the application is clearly without merit, that single justice will refer it to the rest of the court for a vote. And ordinarily, that justice will circulate a memo to the rest of the court recommending a resolution of the emergency application. And I suspect that justice who initially receives it also ends up writing whatever opinion there is, although they're not very long opinions a lot of times. So, like I mentioned earlier, these were very rare. They were sort of backwaters.
We saw them a lot in capital cases.
Yes, that was the main exception, was almost day of execution or day before execution, the capital defendant taking one last try at the Supreme Court, often without really any merit or hope of succeeding, and just reiterating challenges that have been raised before, but occasionally raising some new evidence or raising a new argument. And I remember my term, a gentleman in Texas was strapped down to the gurney, and 15 minutes before the execution, his execution was stayed, and the next term it was vacated by a 9-0 vote. So I can tell you these get very careful attention, but it is certainly not the attention, not even close to the attention that a merits case gets with full briefing and oral argument. I was going to mention the one highest profile emergency application I remember hearing about as a law student. I think it was involving an application to Justice Douglas to enjoin the bombing of Cambodia during the Vietnam War.
Yep.
And he granted it. It was a single justice grant of an application, and he was pretty quickly vacated by the rest of the court.
Well, so it's actually, I mean, so that story, I'm actually working on a book, and the book about the shadow docket, and the book opens with that story. And it's even crazier than that, right? Which is the district court had enjoined the bombing in Cambodia. The Second Circuit had stayed the injunction. The plaintiffs went to Justice Marshall, who was the circuit justice for the Second Circuit. He refused to lift the stay. Then they fly out to Washington, where Justice Douglas is up in the mountains. He comes down off the mountain. He vacates the stay. Then Marshall by himself, Aaron, right, overrules him. But he says at the end of the opinion, "I've called the other justices and they all agree." Right, it was the first telephonic concurrence. So, but Aaron, I mean, the Cambodia example I think is a really cool one because that was rare. That was the exception, right? There was one of those every 15 or 20 years, and now it feels like there's one of these every 2 weeks. We've had just in the last 3 weeks, the eviction moratorium, MPP, SB 8, right? Justice Barrett disposing of the Indiana University vaccination application in chambers. I mean, is this all just because of COVID, or do you think that the court is just more willing to entertain some of these applications than at least when you were clerking, for example, it might have been?
Yeah, I mean, the standard advice you would always give your clients is it's a lost cause. Why would you ever go immediately to the Supreme Court before the lower courts have even heard the merits of your case? They'll never take it. It'll be disposed of by a single justice, and you will look foolish to the court. I think that began to change mostly with the Trump administration, where you had strategic litigation filed against the travel ban, against other Trump administration immigration policies. And those cases were brought, as good litigators do, in favorable forums, usually in San Francisco or Hawaii or the District of Maryland, where they would be, in these single district judges would often enter nationwide injunctions, putting on hold a policy enacted by the duly elected president and not usually not Congress, because not much got through Congress, but it was usually an administrative action by president or one of the agencies. And so I think the court felt that, understanding what was going on here, that you had a single judge and sometimes a single court of appeals being able to put on hold for a year or more something put into place by the political branches, and happening time and time again. My guess is the court, they ought to step in and at least preserve the status quo as of the elected branches taking a position on something. Now, the court certainly had different views. The justices certainly had different views on when to do that. But that's my sense of when it all got started. It's obviously increased, and like anything else, once the court starts doing it once or twice, that the incentives change, and in Texas courts, you learn very quickly that courts are very willing to grant mandamus on interlocutory orders. And once the court started, now they have 20 mandamuses a term probably. So that's where I think it came from. And now with the Biden administration seeing it out, sometimes with the roles reversed, but things like the moratorium and SB 8 and other things, there's obviously a lot to unpack. Happy to sort of talk through that.
Yeah, I think it probably won't be that interesting for the non-appellate nerds for us to go too deep in the weeds. If you don't mind, I guess I just have two sort of quick reactions, which is, I had thought that was a good explanation for what the court was doing, right? That it was sort of deference to the political branches, except that we've seen the opposite, right, over the last, since basically over the current term, right, where, the court has issued 7 emergency injunctions to block COVID restrictions in New York and California. The court, did not, in fact, defer to the Biden administration on immigration policy in the MPP case. And I guess my concern is sort of twofold, Aaron, right? One is, what that says to me is that the merits are driving the bus. And it shouldn't surprise anybody that with this court, right, Trump is going to do better than Biden. Red states are going to do better than blue states. But of course, in emergency applications, that's not supposed to be the only consideration. There's supposed to be, right, other calculus that comes into play. But I think the other part, and maybe this is something where there's maybe less daylight between us, is the more the court is doing this, right, the more the court is actually resolving big questions that impact a lot of people on the shadow docket, it seems like the more they have to write. And the more it would behoove the justices to provide more than a sentence or a paragraph, or in the case of SB 8, a paragraph and a half, right, of analysis, because it's not just that these are impacting so many more people, it's that the court itself, right, is treating many of these orders as precedential. So in the Tandon case in April, where the court blocked California's restrictions on in-home gatherings, there's a whole paragraph at the end of the per curiam opinion where the court chastises the Ninth Circuit for not following the court's guidance in 4 prior COVID cases. Well, all 4 of the cases they cite were orders, not majority opinions. And so I guess, it will surprise no one in this webinar, right, that like I disagree with many of the substantive results in these cases, but I feel like that's inevitable with this court. It's more the process that I think is where more explanation, more daylight, more consistency is what I'd love to see.
Yeah, well, I think those are all fair points. I do think you make a great point about the court feeling like in Tandon, and also I would say in the eviction moratorium cases, that the lower courts were sort of flouting the court's previous orders. And, you could say they're not merits orders, but the court did give pretty clear signals. And that's why I think you've seen the chief be with the other 5 conservatives in the eviction case. And, slightly lesser iteration of this was the MPP case, where I think he felt like the district judge in the Fifth Circuit good job of applying Regent's case, in which the Supreme Court, under an opinion by Chief Justice Roberts, had struck down the repeal of DACA by the Trump administration. And so I think if you're looking for a way to reconcile some of the outcomes, I think that's one thing. But I agree. And as you said, it shouldn't be a surprise. Once the court starts getting into substantive rulings on emergency applications, it's not all of the inquiry, but a big part of the inquiry is likelihood of success on the merits. And so you're going to see the court dividing on lines that are not unknown to us. But I think you're exactly right that this is no way to run a railroad. This is no way to, decide major cases. I guess the caveats to that are, what is the other option if parties in these cases? They could just go back to saying, we're going to go hands-off, but that means single district judge rule effectively for a year at a time, which cuts both ways. That's a non-political deal, because you're going to have appointed judges enjoining Biden actions, Obama appointed judges enjoining Trump actions. And that seems like it's also not a very good way to run a railroad. And the last thing I think to keep in mind is, while we are concerned about these shadow docket orders, they are still interim relief, right? The case was decided by the lower courts on the merits. And I think once all the briefing is, the argument is heard, I think the court takes a fuller look at it, and it may or may not reach the same result. But I do agree with you. This is not the way we would design a Platonic ideal of review of interim orders.
So I do want to get us to the merits docket, but sort of maybe as a segue. I mean, it seems to me there are compromises in between. So, for example, right, you could avoid forum shopping along the lines that you've worried about by giving the federal government the power to transfer any lawsuit seeking nationwide relief to D.C. I think that would solve at least some of these problems. You could bring back 3-judge district courts, I think, for more of these cases, right? Like, in other words, there are things Congress can do to take pressure off the shadow docket, and I'd love for them to talk about it. I do want to say, I mean, you mentioned the Chief Justice, and I think it's fascinating to look at his role here especially, and I think this will give us a good segue into Dobbs, because I know that's where you wanted to start with the merits docket. So, I started by sort of asking what a difference a year makes. And I wonder if you agree with this. It seems to me that the most obvious place where Justice Barrett, as opposed to Justice Ginsburg, really made a difference was actually in some of the high-profile shadow docket cases, right? That like a lot of the big merits cases ended up 6-3, or more than 6-3, but with the 6 conservatives mostly on the same side. A couple, right? Arthrex and TransUnion were 5-4. But on the shadow docket, right, Roman Catholic Diocese was 5-4 with Justice Barrett casting the decisive vote. Tandon was 5-4, right, with Justice Barrett casting the decisive vote. And the SB8 case, I mean, I don't know if it was Justice Barrett or Justice Kavanaugh who was closest to the middle, but it was 5-4 with the chief in dissent. So it seems to me that like there are so many reasons why I think the shadow docket is such an important part of the story. In the narrow sort of piece of like what a difference a year makes, I actually think this is also where Justice Barrett had the most immediate impact, and where we saw the highest number of cases where her presence seemed to be dispositive in ways that, I don't think it necessarily was in as many merits cases. But that leaves me then to sort of ask you, do you see that continuing onto the merits docket this term? And maybe we can start with Dobbs as sort of a tie-in.
Well, I think you make a great point about Justice Barrett's role, and it brings back an earlier point that you made about the court citing its emergency orders as precedent. And then I, maybe push back on that a little bit by saying that when these issues are fully briefed, the court may look at things a little bit differently. And I think that happened in an interesting case that you mentioned. You mentioned the Tandon case out of California, which involved what the court found to be discriminatory COVID regulations against churches. And the court really broke some new ground on the free exercise clause and essentially said, if the state treats any secular entity better than religious entities, then that's a violation, or at least that's subjects that regulation to strict scrutiny. which of course is often fatal in fact in this context. And so people were thinking, well, Smith versus Oregon Department of Unemployment's been overruled, or it's been substantially revised. And then the court heard the Fulton case on the merits docket, which involved the Catholic diocese in Philadelphia declining to place children with same-sex parents as part of the foster program. And the court, it had many ways it could have overruled Smith, or it could have substantially cut back Smith and cited Tandon, or said we're doing the same thing we said in Tandon. But instead it issued a much narrower ruling, I think still a significant ruling, but a much narrower ruling in which the vote was actually 3-3. You had the chief joined by Barrett and Kavanaugh essentially saying, we're going to narrow down Smith a little bit. And of course, you had the three liberals joining in that vote too, probably somewhat reluctantly. So I actually don't count it as 6-3 in that sense. Then you had Alito, Gorsuch, and Thomas saying we ought to overrule Smith. I thought we pretty much had done this in those. And so I think once the court hears a case in full and applies the facts to the law, a lot of times things get a little more complicated and get a little stickier, and you see different coalitions. And so I think that is a good segue in to talk about the Dobbs case. But
can I say one quick thing before you take back the floor for Dobbs? I mean, it's funny because I read that exact setup entirely differently, which is to say, if anything, the fact that the court had already heard argument in Fulton and that the opinions were already underway, and that the court still uses Tandon to articulate a new principle of free exercise clause jurisprudence when it's not exactly like it's waiting for a vehicle, right? I actually think that reinforces many of the concerns about the shadow docket, because here's a context where the court's literally in the middle of writing opinions on the merits docket that touch on almost exactly the same issue. And instead they make new law on the shadow docket. Indeed, the only two justices, right, who are in the same place in both Tandon and Fulton are Kavanaugh and Barrett. So I guess I'm a little more, circumspect that these cases really do make their way back to the court's docket, because as with the eviction moratorium, as with the in-home gathering restrictions in California, once the court sends that kind of message, even at the preliminary stage, it's not really in the government's interest to keep going, right? I mean, the writing's on the wall at that point. And that's not to condemn the practice, Aaron. I think it just sort of drives home how what historically were understood to be temporary interim rulings for various reasons are increasingly permanent, which only to me adds to the sort of the push to put more effort, to get more out of the court when it's doing this. But we could do this all night. I really do want to get to Dobbs, because I actually think.
Yeah, no, that's a great point. It's great to draw the distinction between true emergency orders like the COVID situation that goes away, or the eviction moratorium, which is about to expire, and things that are challenges to major government programs that will be litigated on the merits for years. Very fair point. And I like your reform ideas as well. I think the three-judge panel idea is a good one. Well, let's quickly talk about Dobbs, because I do agree that this is one where Justice Barrett will be very important, as well as the Second Amendment case that the court's granted cert on. Both of those cases will be heard in November for oral argument. And Dobbs, as you probably all know, is the challenge to Mississippi's ban on abortions after 15 weeks. And the district court and the Fifth Circuit both struck down the law under Roe and Casey. And essentially, the Fifth Circuit's a very conservative court, and if they thought it could be reconciled with Roe and Casey, I think they would have done their very best to do that. But the court unanimously agreed that Roe and Casey both essentially outlaw any bans on pre-viability abortions. And so you have a flat out conflict between Mississippi's law and Roe and Casey, as we've always understood them to mean. So when the cert petition goes up, there's no circuit split, because everybody agrees this is unconstitutional under existing precedent. And so when the court grants cert after sitting on this case for a very, very long time without any explanation, Maybe another another question is whether the court needs to have more transparency into its cert process as well as its shadow docket. But the court grants cert in this case, and of course, there's no other way to read that than the court's has serious questions that maybe this law is constitutional, and maybe that means Roe and Casey need to be revisited. So sure enough, Mississippi's brief comes in a couple months ago, and it is a direct attack on Roe and Casey. It's the entire brief, almost the entire brief is overrule Casey completely. It has no stare decisis value under the traditional metrics of stare decisis. And so we're set up for a repeat of Casey, really, in 1992. It's a very similar political dynamics, very similar dynamic on the court. If you think back to 1992, some of you probably weren't alive, but I was. I don't know if I was paying much attention to this case, but you had 5 Republican appointees on the court. Many of those were very new appointees. Plus, you had Justice White, who was an original dissenter in Roe versus Wade. And so everyone had every reason to believe that this attack on Roe would be successful. And, people were pretty shocked when the court reaffirmed the central holding of Roe, as it put it, although it did allow states to put more restrictions on abortion. So, I think the big question is, what is the court going to do? And what can we glean from its prior treatment of stare decisis in other cases, if anything, about what it's going to do in Roe? So I throw that over to Steve if he has any thoughts on that.
So I guess I have 2 thoughts, Aaron, and then a question. So the first thought is, it seems to me I would not sort of poo-poo that part of Mississippi's brief that tries to sort of offer a theory on which the court could uphold the 15-week ban while still at least paying lip service to Roe and Casey, right? That the sort of the part of the brief that sort of frames it as viability is not a immutable, permanent constitutional line. And that as long as there's still meaningful access to at least early first trimester abortions, and really 15 weeks is the second trimester, right? So all first trimester abortions, right? The brief argues that's not inconsistent with the spirit of Roe and Casey. Aaron, I think you and I both understand quite well how incompatible that is with what Casey says. But of course, Casey itself is incompatible with what Roe said. And so I guess, it seems to me that Mississippi, yes, they offer the jugular, but then in some respects that moves the Overton window to make their fallback position actually look much more reasonable when compared to where the law was as recently as 5 years ago, right, in Whole Woman's Health versus Hellerstedt. It's quite a departure. So I guess to me the question is counting heads. Like I could see that intermediate position really appealing to the Chief Justice. The question is it going to really appeal to anybody else? And that's where I wonder if, and so this leads to my question, which is whether you see any tea leaves to that effect in the court's non-intervention Wednesday night in the SB 8 case.
I hesitate to read too much into that. I really take the court at its word to a certain extent that the interesting and complex jurisdictional and prudential issues prevented the court from weighing in there. So I don't know. I read more tea leaves into 2 things. What the court did last term in cases like Fulton, where there was some appetite to take a middle position of making real progress in the view of a lot of conservatives on returning to closer to original understanding of the First Amendment, but not giving the whole loaf to the petitioners in that case. As I mentioned, sort of a centrist morality in a sense there. I think there could be, if you're the chief, that's what he's hoping for again, I think. He does not want to overrule Roe and Casey.
No.
But he would be very open to, I agree, if he, and believe me, he can find a way to write anything. He can find a way to say, much as in Casey, but you have to say we're not revisiting it all, but we find this to be consistent with the whole undue burden and the basic right, and we don't need to go any further to resolve this case. to say that a 15-week abortion ban, which is consistent with what's extant in France and Britain and everywhere else, is sufficient. And then he's hoping to get a vote or two from Kavanaugh Barrett to go there. The problem is, I think the dynamics are so different on this issue and on this case, because in Fulton, the chief could do that, and he had a carrot to offer to Kavanaugh and Barrett, which is, I'll get the 3 more liberal members of the court to join, and this case will be unanimous. I cannot imagine a world in which any of the 3 liberals join an opinion that says viability is out the window as a dividing line. And so there's less of an incentive for Barrett and Kavanaugh to go against what they probably really believe to be the best interpretation of the Constitution in this instance. The other thing I see as a tea leaf, and I'll be interested to hear Professor Vladek's view on it, is the court has been awfully willing to overrule cases. I just did, off the top of my head, I looked back at the last 5 or 6 years, and 5, 6, 7 direct overrulings of cases, and a lot of them are from the 70s. There's one from 1992, the same year as Casey. There's one from 1972, I think the same year as Roe. Maybe Roe was 73.
Roe 73, yeah.
Yeah, but a lot of cases from that same vintage. But at the same time, the counterbalance is the chief is often the one who is looking for that middle ground. Like in Kaiser versus Wilkie, he was looking for a middle ground, not to overrule deference to the agencies completely, but to cut back on it. So I think that dynamic will be very much in play here, and it'll be very interesting to see how it plays out.
So as really quickly, I'll just add, I do think that the Texas case, to me, Aaron, looms large because you can tell a story where the Mississippi ban and Roe coexist. Right? It's not the story that Roe tells. It's not the story that Casey tells. You have to do violence to both of them to get there. But you can tell that story. You cannot tell a story in which SB 8 and Roe coexist. Right? It's just not possible. And so I wonder if that, we know from Wednesday night the chief would have, blocked SB 8 to sort of get the ball rolling on a merits case. And I wonder if to him it actually would have made the court look better to have the chance to split the difference between the two, and to say the 15-week ban's okay and the 6-week ban is not, which might have, in perfect chief mode, right, softened the blow to liberals and completely infuriated, the sort of fervently anti-abortion conservatives. So I don't know, but so it seems to me that like that almost is a closer call than what I think you and I agree is the other huge headline case already on the argument calendar this fall, which is the Second Amendment case out of New York. Do you want to say a bit about that?
Sure. And I want to ask you one question first, though, about SB 8, because I agree. There's certainly a world in which you read a lot into that. And my question has always been, if you're a conservative who believes in separation of powers, you believe in strict application of jurisdictional principles, what does your emergency order say? They don't have a party before them that they can enjoin. And the chief nobody ever really explained in the dissents what you should do. So yeah, maybe as the chief, you want to send that message, but if you're trying to persuade Alito or Thomas who admit that this case has serious questions about the constitutionality under existing precedent, how would you persuade them to sign on to an order?
I think the order. So the short answer is, right, 2 of the 8 defendants. One was a district court judge, right, who was named as representative of a class of all district court judges in Texas. One was a district court clerk who was named as a representative of all district court clerks in Texas. So I think at the very least the court could have enjoined the 2 of them. I actually think, Aaron, the right thing the court should have done is not issue an injunction. I think the right thing the court should have done is vacated the Fifth Circuit stay, and sent the case back to the district court with, telling the district court to hurry the hell up and decide the class certification question, and decide the preliminary injunction question, which of course would then be immediately appealable without any of the. So if it were me, and it wasn't, right, I write an opinion that says, this law violates Roe. Roe is still on the books. right? We can enjoin at least some of these defendants without violating Article 3 principles. The district court has the power to certify a class that could allow the injunction to run to enough defendants to actually block this law from being implemented. We are therefore enjoining these two defendants, and we are vacating the Fifth Circuit's administrative stay and remanding the case with instructions to the district court to proceed expeditiously to both class certification and the motion for a preliminary injunction. That's what I would have done.
Okay, well, that's great. That's very creative, and I think that gets into a lot of the procedural history of what was going on in the district court and Fifth Circuit, which is really complicated.
Yes. But I will just say though, because I can't resist, and I have to be a little bit of a nudge in this conversation, right? I don't disagree, right, with the paragraph and a half of that the majority wrote that there are open procedural questions in this case. But I just go back to Tandon, where the court ran right past, right, not an open procedural question, but a procedural constraint on its power, which is that the All Writs Act requires that the rights at issue be indisputably clear. And that was just no, never mind to the same 5 justices in Tandon. So we're not going to agree on this. I think that in the SB 8 order looks a lot better in the abstract to me, Aaron, than it does in the context of the other 7 injunctions the court has issued this term.
All right, fair enough. We have to agree to disagree on that.
Yep.
But let's talk about the Second Amendment case briefly, which is another one that the court sat on for quite some time, and come back in a minute, and finally granted cert. And in fact, this was after a decade of denying cert in Second Amendment cases, since the court decided Heller and McDonald in 2008 and 2010. And there's, of course, a lot of speculation. Why is the court denying cert on these cases? There's a lot of circuit splits arising over a variety of issues and types of gun regulations. And I think the only inference one can draw is that neither side was very sure where the other was going to come down, where the chief was going to come down, where Justice Kennedy was going to come down. And so they
don't matter anymore.
Yeah, that just does not matter anymore. And so this case is called Bruin versus the New York State Rifle and Pistol Association. Comes out of New York City, which requires a permit to carry your weapon outside of your house. And the permit has to be based on a personalized showing of some need that differentiates the applicant from the rest of society. And in practice, it's been applied to mean that you never get a permit to carry your weapon outside of your house. And so this case has been teed up on really a core issue, which is in Heller and McDonald, the court focused on bans on keeping arms. Second Amendment says keep and bear arms. Heller and McDonald say you can keep arms in your home for self-defense. That's at the very minimum, the core of the Second Amendment right. This case focuses on bearing arms. And the petitioner's position is that keeping and bearing arms are textually on equal footing in the Second Amendment. They're equally core rights as a matter of history, as a matter of text, and as a matter of tradition. And therefore, this law is just flat out unconstitutional. It gives discretion to some government bureaucrat to decide whether you really need to exercise that fundamental right or not, in a way that we wouldn't tolerate with respect to any other enumerated rights in the Constitution. So one other point I'll make on this is one of the circuit splits that has arisen in this area is, what type of test applies to determine whether gun regulations are constitutional or not? There's so many different types of gun regulations. There's really 4 safety regulations. There's Brady Bill waiting period type of regulations. There's restrictions on, if you're a domestic abuser, can you get a gun? And then there's things that are just essentially bans like this bill. I'm sure that's not how New York would characterize it. They would characterize it as a regulation on the public carrying of firearms. And so there's been a debate over that. And I think the petitioners try to bypass all of that and essentially say if it's a core right that's protected by the history and text and tradition of the Second Amendment, then we don't really need to get into the tiers of scrutiny that we all know and love in con law. It's just unconstitutional, no matter what tier applies. I'm sure New York will be arguing, I think, for some form of intermediate scrutiny that gives a fair amount of deference to the governmental interests. And what all this does for Texas with open carry, I don't know. That's another. I'd be interested to hear Professor Vladek's thoughts on that, as well as in general on the case.
Yeah, I mean, I do. We have, I think, 7 questions in the chat, so I want to get to those. I'll just say briefly. It seems to me that the most important thing the court did not do in Heller and McDonald was give lower courts any guidance about cases beyond Heller and McDonald, and it would be an enormous waste of time and energy for the court to do that again. I have my views about how I think this case should come out. I suspect they are different from yours and just about everybody who's watching this. But of course, again, the votes are the votes. Aaron, I think it would actually be important in some respects if the majority is going to strike down the New York law, for the majority to reinforce that actually there is a wide range of permissible gun regulations that states and the federal government can carry out, especially in a day and age when there are some very loud, prominent Republican politicians, including members of Congress, asserting that the Second Amendment is absolute. Right, and contradicting the plain language, right, of Justice Scalia's opinion in Heller, which literally says the opposite. And so I guess, I come at this from a more fatalistic, I guess, view of where this case is going, which is that the most important thing to me, assuming that there's at least 5 votes and perhaps 6 to strike down what New York did, is for the court to actually provide meaningful guidance that doesn't just, sort of help to inform what other kinds of restrictions are unconstitutional, but Aaron, that helps to reinforce what kinds of restrictions are constitutional. Because I think, there are at least some legislators for whom that's going to matter, right? What the court says, the actual guide. In other words, I think part of where we've been over the last 10 years with the debate over gun reform is everyone appropriating different passages from Heller and McDonald to, read them to mean radically different things. And here's a chance for the court to provide clarity. And I think it would be, whatever that clarity is, I actually think we'd be all better off for having it.
Good luck with that. I agree. And this is actually probably an area where the two of us are closer. I guess I'm a little more of an old school judicial restraint conservative in a lot of ways, that I think there ought to be some ability of local and state governments to tailor solutions to those that are favored by their constituents. I happen to believe that for abortion as well as guns, unlike some people on the other side. But, and so I do think it would be helpful if the court could give some guidance there. I think, this is an easy case because it's such an extreme case, and that's why the court took it. And that's probably why they're not going to give us very much helpful guidance. But look, I agree that I think, the court doesn't want to be, I don't think it wants to be, the gun oversight board for the entire country. Certainly the chief doesn't want that, any more than it's become the abortion oversight board or, the First Amendment. It's kind of unavoidable to a certain extent.
Yep.
But I don't think they want to get into that. And so guidance would be nice, but I'm not holding my breath on that.
Just one last thought, Aaron, before we turn to questions. I mean, you and I had identified a handful of other cases that we thought would be, sort of potentially big cases. But at least where we are right now, I mean, I think these are the 2 blockbusters that are on the docket. The court, I think the count is the court's granted, I think, 26 cases so far. So in theory, it's not even halfway to filling its docket. But at least where we are, these seem to be the 2 biggest ones to watch.
Yeah, no, I agree. There are plenty others that are out there and that may crop up in the search.
And if we had 3 hours, we would do them all justice.
Yeah, that's right. But I think since we have so many questions, why don't we jump into those?
Yep. Pete, do you want me to ask them or do you want to ask them?
I'll go ahead and take it. Yeah, so Tanner Baird asked a great question, and he says, in their Fulton concurrence, Kavanaugh and Barrett seem to express interest in looking to other First Amendment precedent to replace Smith instead of establishing new originalist case law in the Free Exercise Clause. So do we think that this foreshadows a greater deference to precedent that could have implications for an incremental approach when deciding Dobbs?
Aaron, you want to take that first? You want me to dive on that grenade?
I don't think that particular opinion tells us too much about what the court could do in Dobbs, just because the history of the Free Exercise Clause jurisprudence is so unique where you had a pre-Smith body of case law that probably looks pretty appealing to a lot of members on the court right now. And then, of course, you had Smith and you had RFRA. And so the court has something to look to in the past. There's no pre-Roe case law. There's no pre-Casey case law that anybody on the court wants to look to. So, you know, I think it tells us about as much as the fact that they voted in the middle and they were looking for something to anchor themselves to. But I'm not sure there's such a body of case law that's readily available for Kavanaugh or Barrett to turn to with respect to abortion.
Yeah, I mean, I'll just echo that just to say that I think, I mean, when people talk about the 3-3-3 court, which I think is a wild overstatement of what the court is, to me, you know, the difference that separates the 6 conservatives into 2 camps has nothing to do with their substantive views and everything to do with the sort of that term incrementalism, right? Their willingness to engage or not engage in incrementalism. And I just think that abortion is going to be the last place where we see that. Whereas, you know, Aaron, I suspect there are other contexts where Justice Barrett and Justice Kavanaugh actually might very well, right, be more incrementalist along the lines of the chief compared to, you know, Thomas Alito and Gorsuch.
Awesome. Now, Warren Bloom asks, what general insight did the last term give us into the 3 Trump-appointed justices, and especially Amy Coney Barrett?
You know, I mean, I'm curious what Aaron thinks. I don't think Justice Barrett really stuck her neck out a lot during her first term on the court. I mean, I can name her dissenting opinions, but they weren't necessarily in super high-profile cases. You know, as we talked about, Aaron, I think her most visible decisive votes were probably on the shadow docket, where of course there's that's not as visible as the merit stuff. I think we probably learned a lot more last term about Justice Kavanaugh, in the sense that I had expected, or at least suspected, that he would be very much in alignment with the chief on, you know, whenever there were sort of fractional divisions, that he'd end up closer to the chief than the other conservatives. And I actually think that's been less true than I had thought, than I had expected. That, you know, we're seeing the chief by himself going over to the lefties a little more than we're seeing the chief and Kavanaugh doing that. And I think what that portends is that, you know, to me at least, right, he more than Justice Barrett is now the median vote in most high-profile cases, right? There are going to be a handful of cases where Justice Gorsuch's libertarian streak, I think, pushes him to the left. But Aaron, I think those are fairly predictable. Right. Whereas I think in the close sort of charged institutionally divisive cases, it's really, you know, I can't think of a case where Kavanaugh was in the dissent and Barrett was in the majority, right? Like, I feel like that's where the center of gravity is.
Yeah, I agree with that. I think, you know, and I think that example of Justice Kavanaugh in his first term on the court, sticking more closely with the chief, but now moving a little bit more on his own, developing a little bit more of a distinctive jurisprudence. Counsel's caution about drawing any inferences about Justice Barrett from her first term. And I mean, when I've done Federal Society events, a lot of people question, you know, Justice Barrett's not conservative. She's, you know, she hasn't gone out on her own enough. She's not been with Gorsuch. And I've always said, well, you know, the first term on the court is a very unique time. And I think it speaks well of somebody that they're humble and they're cautious and they're learning the ropes a little bit in their first term on the court. You think, and what I always say is, before you get too depressed about this, my fellow conservative friends, is remember Justice Alito. He was first on the court. He was with the chief a lot and disagreeing with Thomas and Scalia. And now Justice Alito is one of the most consistent conservative votes on the court, and often votes with Justice Gorsuch and Thomas. So I agree with that. I think we'll see more of Justice Barrett in her personality and her jurisprudence come out in the next term.
Can I just say, can I just shed a crocodile tear for conservatives who are depressed about the Supreme Court? I mean, you know, guys, come on. I mean, yes, that the Supreme Court in the first term with Justice Barrett did not overrule every single precedent on Justice Thomas's hit list does not mean that all of a sudden these justices are squishes. and that the court is in fact moderate. I mean, I will die on the hill that this is as conservative a court as we've had since the 1930s. And if that's still not conservative enough for you, well, Justice Breyer is doing his best to help. So,
well, time will tell, right? I mean, there's a reason conservatives have that skepticism about Republican judicial appointees. You can rewind again back to 1992 with Casey, and people thought this is the most conservative court ever. We've got, Roe is on its last legs, and all these cases will be overruled with Justice Kennedy and the great Justice Souter joining the bench to join the conservative bloc. So that's
I mean, Aaron. I mean, I don't think anyone's going to argue that Barrett and Kavanaugh are comparable in this space to Souter and Kennedy and even the Republican appointed Justice Stevens.
No, I agree. I'm just saying, look at the history behind it. Look at even as recently as not this past term, but the term before, with the DACA case and the census case and some pretty liberal outcomes in ones where the chief was playing more politics than law. And now the big difference is, of course, the chief is not the center of gravity anymore, as you rightly point out. So anyway, we're agreeing on this. So
yeah, I'm just going to respectfully dissent. I'm going to respectfully dissent from any suggestion that a majority opinion written by John Roberts is liberal. That's a bridge too far.
Okay, well, we got Bostock from 2 terms ago, 6-3 with
that was Gorsuch. That was statutory interpretation.
Yeah, I know, but that's my whole point. This is why conservatives are saying this. I happen to.
Yes, sometimes the law actually requires results that are not in line with conservative political agendas. It's amazing how that works.
That's conservatives for you. That's the difference. But, all right, let's move on.
This is good sport.
Towards those.
No.
On that note, there was some discussion of Justices Kavanaugh and Barrett as being conservative institutionalists whose concern for the court's reputation might moderate their conservative votes. So do we think that the outcome of the SB 8 order discredits this theory? And that is Wes Dodson's question.
So I would say, I wouldn't say one order alone could discredit that theory, but I do think the body of work from the last term pushes pretty heavily against that. I mean, I mentioned, I think earlier, the number of times where the chief was in dissent with the 3, remaining Democratic appointees, cases where either Kavanaugh or Barrett could have tipped the balance if they had gone the other way. So, we'll see what happens in Dobbs. That, of course, will be the big institutionalism case. But I don't think there's much data from this term to back up any argument that these were, that these were sort of justices voting for institutional reasons as opposed to based on their own particular ideological commitments.
Yeah, I think that's fair. I mean, I think Fulton is probably the best counterpoint to that. They certainly expressed misgivings about overruling a decision, even though they agreed that decision was incorrectly decided. They expressed misgivings because they weren't certain what should replace it, and it wasn't necessary to decide the case. So I would characterize that as, I'm not a big fan of the word institutionalist, but restraint-driven reasoning. Maybe, but at the end of the day, I think the question is going to be, in cases like Dobbs and others, for Barrett and Kavanaugh, what do they think the Constitution means, and what do they think principles of stare decisis mean? How heavily they're going to weigh those two against each other, that's where the case will be decided. I tend to agree. I don't think they're going to be in the chief camp on those cases.
I'll just say, for one data point, pushing back a little bit against Fulton, I would encourage folks to read Edwards versus Van Noy, where a 6-3 majority in an opinion by Kavanaugh, joined by Barrett with no separate concurrences by either of them, chucks to the woodshed a precedent that nobody had asked the court to overrule. And so it seems like, that's not that when I mean, Fulton to me is the only example that we saw all term of what, Pete, per Wes's question, I think some of us had been expecting to see more of.
I think you meant chucks to the watershed.
whatever. Metaphors at 8:30 at night, they're hard.
I'm kidding. You had the metaphor right, but since it was overruling Teague's watershed rule, I was kidding.
Sorry, I missed the pun. That's the problem. It's 8:30 at night, so I missed the pun. And it was a good Fed courts pun, Aaron.
That was the one I thought of from last term, where the court just blatantly overruled a case
that no one asked it to.
That's true. Although you could argue that was good housekeeping. That, hey, we're giving the kind of guidance to courts that you want in the Second Amendment context by telling them we're not going to have any more watershed rules about retroactivity. So stop bringing us these cases.
I thought you were just giving us a whole song and dance about conservative judicial restraint.
I believe in that, and I believe not keeping ridiculous precedents on the book that are never going to be satisfied. Right? If there's never been a watershed case for whatever it was, 30 or 40 years, dating back to the Berger Court and through times in the Rehnquist Court when Kennedy and O'Connor were very much ruling for capital defendants and ruling on criminal procedure cases from the middle. You got to it's a fair point to say, let's just clean up the law in this area. But anyway, it's a fair counterpoint, and I think that's an interesting case you could do another 30 minutes on.
Well, as Professor Vladeck said, it is 8:30. So Professor and Mr. Street, thank you both so much for coming. This was very insightful. I'm going to call up President Scobie so that she can give us a conclusion here.
Well, thanks again, Mr. Street and Professor Vladeck, for talking with us tonight. It was a really great event, and I think we're all really excited to kick off the year. Just a few quick announcements before we wrap up. I put a couple links in the chat to our next upcoming events. So mark your calendar. Next Tuesday, September 14th, is Originalism 101 with Professor Ilan Werman and Professor Sandy Levinson from UT, moderated by Judge Charles Eskridge from the Southern District of Texas. And then we're also holding next week on Thursday, the 16th, our first social event. It'll be an introduction to FedSoc and the Texas Review of Law and Politics. So mark your calendar for that too. And the link to RSVP is in the chat. So again, please consider joining the Federalist Society. Check out the website for more info and on membership and on upcoming events. So thanks again for joining, and